All right, today we're starting Chapter 4, which examines civil liberties and public policy, and I have to apologize in advance if I start talking faster than normal, because civil liberties and civil rights is actually one of my favorite topics within government, and so I tend to get kind of enthusiastic and passionate about it, so I apologize. But first of all, I want to take a second to clarify the difference between the two terms civil liberties and civil rights, because I think they often are incorrectly used interchangeably. Civil liberties are all people are born with them. Essentially, humans get them simply by being born, and it's the role of the government to protect these liberties from being limited or stripped. Another way to look at it is liberties are key fundamental principles that the government must uphold. And again, people are born with liberties, and they are protected by the government. Conversely, civil rights people do not get unless the government gives them to them. They also involve the protection against discriminatory treatment, and we're going to look closely at the 5th and 14th Amendment, which address the protection against discrimination from both the national and state governments. So again, liberties people are born with, rights people are given by the government. And there are several sources of protection of both liberties and rights, and we are going to focus on liberties in Chapter 4. The Constitution clearly states in some of its language how the government will protect liberties and rights. Ex post facto, bills of attainder, habeas corpus are all banned in the Constitution, and so the language clearly says what people are guaranteed in different situations. So for example, a bill of attainder is not constitutional, meaning that people cannot be convicted without any kind of judicial trial. Ex post facto is after the fact, and so there are statutes of limitations that must be recognized in certain situations, and neither the national nor state governments have the authority to take away these liberties from the citizens. The Bill of Rights, obviously, was added almost simply for the sake of protecting certain guarantees by the government for the people. And so if you think back to what the Anti-Federalists were most fearful of, they were fearful of a tyrannical government which would oppress the individual citizens. And so to ensure that citizens would get to enjoy different liberties and rights, the Bill of Rights were added, and a lot of explicitly written liberties and rights are clearly laid out within the first 10 amendments. There have since been different pieces of legislation that have addressed both rights and liberties, and we will get into these more again later. But the Civil Rights Acts of both 1964 and 1968, and then the Voting Rights Act of 1965, clearly stated what both states and national governments were not allowed to do in terms of denying people rights on the basis of race. And lastly, court decisions can upheld or reaffirm what rights and liberties need to be protected. So for example, Brown versus Board of Education stated that separate facilities are inherently unequal. And so people, again, on the basis of race, cannot be denied nor discriminated against in terms of public facilities. Roe versus Wade upheld the liberty of the right to privacy between a doctor and his or her patient. And then different state constitutions have even more explicitly written out which liberties will be protected by those states. The First Amendment covers a lot. It has both a lot of breadth and depth, and so we will take quite a bit of time examining each one of the amendments, and the First Amendment we probably will have to address in a couple of different presentations because it covers so much. But some of the civil liberties, and again, these are going to be powers that people are born with, they need to be protected by the government. The First Amendment includes freedom of religion, speech, press, assembly, and petition. And we are going to look closely at all these different liberties, and we're going to start with freedom of religion. There are two parts to the First Amendment that address specifically freedom of religion: the Establishment Clause and the Free Exercise Clause. And they sort of approach protection of this liberty from two different angles. The Establishment Clause makes it so that the government cannot set up or establish an official national religion, nor can the national government help support any one religion. So although Establishment Clause might lead someone to think that it's the government establishing something, this clause actually prevents the government from establishing a religion. There have been a couple of significant Supreme Court cases where the rulings upheld the Establishment Clause. In Engel versus Vitale in 1962, the Supreme Court ruled that prayer in public school is in fact unconstitutional. And so attending Cathedral Catholic High School obviously is a very different situation because we are not a government-sponsored institution. We are a private institution, therefore prayer on our campus is of course acceptable. However, at public schools, if a teacher, an administrator, any staff member, any state official were to sponsor a school prayer, he or she would be acting unconstitutionally. And there are all kinds of examples of other rulings that have fallen in line with this same principle. For example, a couple years ago in the state of Texas, before a high school football game, the players on the football team decided that they wanted to have a pregame prayer. And the coaching staff knew that they were not allowed to lead it, so they let the team gather in a huddle, and then the coaches moved to the peripheral of the circle or the huddle. And as one of the team captains led the prayer, a couple of the coaches dropped their heads just as sort of a habitual practice of once a prayer begins, people lower their heads and bow their heads. Well, somehow the school got word of this, and because of two reasons. One, first, that coaches who are school employees were present in the locker room, and because the two coaches who had dropped their heads had quote-unquote participated in the prayer, it was deemed to be a violation of the First Amendment. Now, something to consider is how would a government, how would a school, how would anyone outside of the locker room know what had gone on? Obviously, someone within the confines of that locker room told someone about this prayer, and it was through that word of mouth that a school official heard about this pregame prayer. And the two coaches who quote-unquote participated in the prayer, they actually received sanctions and they had to face consequences. They were volunteer coaches, so I believe they were suspended for 2 weeks and they had to miss 2 games. But something as simple as bowing heads was deemed to be them sponsoring prayer. And because they are part of a public school, that was viewed as unconstitutional. So moving into another example of what sponsorship of prayer can look like, let's talk quickly about the Wallace versus Jaffrey Supreme Court case from 1985. This was in the state of Alabama, and in the 1980s, there was an Alabama law which authorized teachers to set aside 1 minute at the start of each day for a moment of, quote, meditation or voluntary prayer. So the teacher would not lead a prayer, but rather teachers were required to give students 1 minute to use that time for meditation or voluntary prayer. Ishmael Jaffrey, who was an American citizen, was a resident of Mobile County, Alabama, and a parent of 3 students who attended school in the Mobile County public school system. 2 of the 3 children were in 2nd grade, and the 3rd was in kindergarten. On May 28, 1982, Jaffrey brought suit naming the Mobile County School Board, various school officials, and the minor plaintiffs' 3 teachers as defendants. He sought a declaratory judgment and an injunction restraining the defendants from maintaining or allowing the maintenance of regular religious prayer services or other forms of religious observances in the Mobile County public schools in violation of the First Amendment, as made applicable to states by the 14th Amendment of the Constitution. He also further alleged that 2 of his children had been subjected to various acts of religious indoctrination, and that the defendant teachers had led their classes in saying certain prayers in unison on a daily basis. that as a result of not participating in the prayers, his minor children had been exposed to ostracism from their peer group classmates, and that Jaffrey had repeatedly but unsuccessfully requested that the prayers be stopped. So obviously 3 years in the making, once this case made its way to the Supreme Court, the Supreme Court did in fact rule the Alabama state law unconstitutional. So although the teacher didn't necessarily lead a prayer, although the minute could be used for meditation purposes, that moment of silence was deemed to be in and of itself unconstitutional. And so what the Supreme Court also had to do is they had to figure out a objective way to measure if something violates freedom of religion. And so as a result of another Supreme Court case, Lemon versus Kurtzman in 1971, the Lemon test was officially established. And this details the requirements for legislation concerning religion. And it is threefold. The first part of the Lemon test is that the statute must not result in an excessive government entanglement with religious affairs. This point is also known as the entanglement prong. The second point is that the statute must not advance or inhibit religious practice. This is also known as the effect prong. And lastly, the statute must have a secular legislative purpose, and this is known as the purpose prong. So the Lemon test is a three-prong test which state legislatures must adhere to before they pass state laws. And the prongs are the entanglement prong, the effect prong, and the purpose prong. And sometimes that does show up on AP tests, so just make sure that you make note of that. All right. I got ahead of myself. So that is what the government cannot do. In terms of what people are allowed to do, we need to look for a second at the free exercise or free expression clause. What this essentially entails is that the government cannot stop a person from practicing religion. Now, there are exceptions to this. For example, the Supreme Court case of Reynolds versus the United States was dealt with the topic of polygamy. So polygamy, meaning married to more than one spouse at one time, is illegal in the United States under both state and federal law. However, the Church of Latter-day Saints did practice polygamy. And this became a Supreme Court issue because the Supreme Court had to determine if the act of polygamy was constitutional, just as the belief in polygamy was constitutional. And so the result of this case was that there is a difference between religious beliefs and religious practices. So people essentially can believe in whatever they want. Beliefs obviously are in someone's mind, and it would be difficult to enforce that. However, practices are acts, and the government does have the authority to deem acts unconstitutional or illegal. And the Supreme Court ruled that although the Church of Latter-day Saints could believe in different religious ideas, they could not practice acts that were unconstitutional. So sort of like the Supremacy Clause makes it so that no state law can trump the authority of a national law, no religious practice can trump state or national laws. So if the act or the practice is illegal, people cannot play the, well, it's my religious belief card. The act cannot be protected by saying, well, the free exercise clause lets me do whatever I want. Because if you think about it, then if people said, oh, well, that guy murdered someone because it was his religious practice or his religious belief. So the Supreme Court drew a line differentiating between religious beliefs and religious practices. And then the last case was the Supreme Court case from 1990, Oregon versus Smith, in which the Supreme Court determined that the state could not deny unemployment benefits to a person who had been fired for violating a state prohibition on the use of peyote, even though the use of the drug was part of a religious ritual. Although states have the power to accommodate otherwise illegal acts done in pursuit of religious beliefs, they are not required to do so. So again, thus just reaffirming the limits of the free exercise clause.